Thank you so much, Kasha. Much appreciated. I'm happy to start us off. We have four of us. I'll introduce all of us in a minute, but I just want to first start by saying hello and welcome and thank you. Thank you for spending your lunch with us. We know that everybody is busy and it is a wild world out there. So it means a lot to us that you've chosen to care about this topic and that you've chosen to be with us today. Also want to say a huge thanks to LAC, Legal Aid Association of California. I personally am a huge supporter and a longtime friend. I began my legal aid career in 2006 with Legal Services of Northern California way back when. And when I moved into my executive director role at Senior Legal Services, LAC was absolutely critical in helping me develop as a person and as a leader in this field. So thank you very, very much. And I also want to just take a minute to do a quick grounding before I introduce us, because the topic is a difficult one. And like I said, the world is a crazy world. So I really think it's important just to stop and breathe and find some gratitude, something that you're grateful for right now. Maybe it's just that we're warm, I hope, and fed, I hope, and that we have the capacity to take this learning in. We have the capacity to be here right now. That is a gratitude enough. And then with that, we can take that gratitude and that ability to learn and share it with others. So thank you again for being here. So I'm gonna introduce us. My name is Tanya Harmony Ridino. I am currently an estate planning attorney and a family law attorney with my private practice called Harmony Law. And I was previously executive director at Senior Legal Services and, as mentioned, had a long history of legal aid with other organizations as well. I am joined today by Robert Allen. He is also an estate planning attorney, also a bilingual attorney, and he is a partner with Allen and Caroselli in Watsonville, California. We also have on our Childcare Safety Plan Coalition team, Miriam Stombler. She is a retired Santa Cruz Assistant County Counsel and also previously worked with the San Francisco City Attorney's Office. Is that correct? Awesome. And last but not least, many of you may know Kellie Morgantini. We're really happy to have Kellie with us. Kellie worked for over 3 decades, I believe, with Monterey Legal Services for Seniors, and she retired as their executive director 3 years ago now. Is that something like that? Well, who's counting? She's not really retired. She's working her butt off with us.
There you go.
So thank you so much. And I also wanted to mention that our team is a lot larger than us four. So at the end of the show, we'll give you our website. It's communitybridges.org. You'll see that our coalition is a really amazing team of immigration attorneys, nonprofit organizations, education, government. We've got a really wonderful group of volunteers behind us. So got to do a quick shout out to our entire coalition before we move on. Okay. Oh, and just other housekeeping. We're really happy to be with you for 90 minutes. Ooh, it's a whole 90 minutes. Sometimes we rush through this quicker, so we've decided that we are happy to receive your questions as we go. We'll try to keep it interactive, and Kellie is gonna man that with her or woman that I should say, and we'll handle those as we go. So feel free to pop them in. We can go back and forth that way. All right, so why are we all here? I'm going to get us started again by just talking about the importance of childcare safety planning. The world, again, is a wild world out there, and there's not much we can control sometimes. There's a lot of increasing natural disasters. Everybody is well aware of the increased immigration enforcement, and childcare safety planning is one concrete thing that we can hold and we can help with and we can hand to somebody, and it provides structure to those potential caregivers. It provides peace of mind to the families, and it provides some ease of transition and inclusion to the children themselves. So we feel really passionately about this project and happy to share it with you guys now. Some of the goals of today's training and the goals of this plan itself. Number one, we're really here to empower parents. We really want parents to understand the differences between caregivers and guardians and have them feel empowered to choose which tool they want to use and understand how to do that. The Childcare Safety Plan big goal is avoiding foster care. When this document is done and in place, if there were a child left alone and if a social worker were to show up, they should respect this as the wish of a parent that has been noted. And we've in Santa Cruz worked closely with our Child Protective Services, social workers, and so they're well aware of the document. And it's a very important goal of the toolkit. Again, a goal is the full inclusion of the child. A caretaker might end up with a child and might be able to do one thing with the child, but not another. For example, they might be able to enroll them in school, but they can't enroll them in Little League. So those little details are super important. Another goal is to facilitate conversation. So important just to be having these conversations and to avoid guardianships except when necessary. So Rob's going to go a lot more into detail of AB 495 and the brand new joint guardianship. So this is a little less concerning than before, but still we really want to help parents stay out of court if at all possible. I'm sure you're all aware that most people don't want to go to court, and we're doing what we can to avoid that by using the caregiver designation. So a little bit about our coalition, and then we'll get into the meat of the stuff. We have been around since 2017. We, as I mentioned, have lots of partners. Community Action Board has been a primary partner from the beginning. Community Bridges has been a primary partner from the beginning and is currently our fiscal sponsor. Salud para la Gente is a medical facility, and they took this on over the summer and busted out 500 of these in 2 months, helping over 800 children. So it's an amazing example of what an organization can do when they say yes. We have all our unified school districts, County Office of Education's involved. Our local rapid response teams are very much involved, and our welcome networks. So we invite all of you to build similar coalitions in your communities. It's amazing what many hands can do. So just to back up a little bit and let you guys know again, we began, as I said, in 2017. The first federal election in 2016, people are well aware the immigration enforcement then was also very difficult. And people may remember that there was a bunch of guardianship clinics popping up everywhere, the Clínica de Tutela, something like that. So I was really concerned because I have represented quite a lot of parents in guardianship petitions. And I was concerned that many people may not be aware how difficult it can be to terminate a guardianship, even a well-meaning guardianship. Most of you are probably well aware of those concerns now. And fast forward to 2025, Governor Newsom finally got wind and fixed it slightly with the joint guardianship. So it's a little bit less concerning, but regardless, that was why we originally began to try to give as much strength as possible to caregivers and to try to avoid guardianships when possible. So we have since then gone on. We came back in 2024, ready to go, and we have been going strong ever since. We have about 200 volunteers in our team, and like I said, faith-based groups, schools, or lots of wonderful partners. So fast forward to today again. One thing I think is really, really important to understand right off the bat is that childcare safety planning is a part of family emergency preparedness, but it's not all of it. So we really want to always emphasize the other things that parents also need to do to be prepared. The ILRC and other family preparedness documents give a nice extensive list of things that families should be aware of. Of course, know your rights. These are just some of them. Consulting with immigration attorneys, updating school cards, etc. All of those things are still very important with family preparedness, but this is one critical aspect, naming a caregiver, which in my opinion is the most important part of family emergency preparedness. But it's not the whole picture. So you might want to make sure to keep that in context. Also in context, we just want to again recognize that these are really difficult topics, and we as a group, do our best to always come, with trauma-informed care. We have mental health partners, and we really do our best to be sensitive to the topic itself and always share the better safe than sorry, or mejor prevenir que lamentar. So definitely the idea that once you've done this, you have some more peace of mind. Stress is hopefully reduced, but just keeping that in context. And we also keep it in context by saying safety planning is for everybody. This is not just for undocumented families. I have one for my son. Anything can happen to any of us at any time. So this is useful for all families. And it also doesn't replace estate planning. I just want to mention that as well. Families still need all those documents, all the important estate plan documents. This is the emergency addition to those other tools. All right, I think I'm going to turn it over to Miriam, if I'm not mistaken. Or am I?
All right, happy to take over. Okay.
Thank you, Miriam. I appreciate it.
Thank you, Tanya.
Mhm.
Yeah, so my role today is to really familiarize you briefly. I'm going to jog you through the document because I don't have time really to walk you through it. But I do want to say, okay, here's what the CSPs do. It's free, it's bilingual, it's a simple template, and it's designed, we call it our Swiss Army knife, where it's designed to address any multitude of situations that could occur in a family emergency. And today we'll be really focusing on immigration-related emergencies, but because there's some extra nuances added when immigration is involved. But but this is really truly, as Tanya said, for all families. It's a fill-in-the-blank form, and there's 5 things. You can do it with one hand, and I'll tell you later the 5 things a family needs to fill out. It's a document that will be signed either in front of 2 witnesses or a notary. And it's a document in which the parent designates who they would like to take care of their child in an immediate emergency, perhaps down the line if a guardianship is ultimately needed. And it includes other documents that, are a packet of information. It's all kind of one neat, cozy packet of information. So next slide. So that's what the CSP does. What it does not do, it does not require court approval. It's sort of a self-executing document. It does not change the legal status of a custodian, a guardian, or a parent without a court order. And it does not allow non-attorneys to practice law without a license. It is a self-help document for parents, and they can be guided through it. And that's where we encourage you to get involved. So the next slide, and I think you will see in the chat, at some point, you'll see the link to the actual Childcare Safety Plan. So the key elements of this are the safety plan itself, 5-page document with 5 things to fill out. An attachment, we have the caregiver authorization affidavit attached for the benefit of the caregiver to use down the line if needed. We have an optional nomination of a future joint guardian. And we'll talk later about guardian versus the new joint guardianship now authorized by AB 495, at least to the extent we know at this time. There's an optional power of attorney for travel if the family's goal is to have the child travel abroad to reunite with the parents. And also want to point out that, of course, free, bilingual English, Spanish at this point. And we are now enhancing our document to make sure that it is compatible with and furthers the intent of AB 495, which we'll talk about later.
Yeah. Let me just jump in real quick, Miriam, because I was supposed to do those
Anyway,
slides, so I apologize. But we do want really, we hope that people have their CSP in hand, and if not in front of them, Miriam's going to go through every every detail so that you guys leave this webinar feeling comfortable filling this out with families. We want you to be the empowered ones that take it and run with it. So hopefully that has got put in the chat where you can download it yourselves as well. And what Miriam just said about AB 495, enhancing it. Again, we've had this for a long time, and we've provided the caregiver authorization affidavit and the nomination of guardianship form in it for a long time. And now those tools just got beefed up by AB 495. So we're really excited by that. And again, the CSP still is the best place to hold those two new tools and hand it to a family with them with ease.
right. And I appreciate that. Consider this a toolkit with very finely tuned tools for all different types of circumstances. Okay, so next slide. Okay, so this is the part where I jog you through, and I love this because it says the care, the plan, and the share, and we will talk about each of those. Next slide. So this shows you the graphic of the first 2 pages of our child care safety plan, the first 2 of 5 pages. You can see that it's a fill-in-the-blank template. So the 5 things: we identify the parents, we identify the children, identify the caregivers, the parents sign it in front of either 2 witnesses or a notary. So that's it. That's it. You all have a child care safety plan. Of course, and with this child care safety plan, the caregiver now has the parents' written and witnessed consent to go forth and care for the child and obtain the full panoply of services that that child might need. Because all of the other details are in the written template, and it is also modifiable, which we'll talk about in a moment. So it sounds simple, and it is simple, but of course, there are nuances. For example, let's say we'll go to the next slide. Actually, I want to go back to the previous slide. So when we tell parents, fill in the name. So the very first section is where the parents identify themselves. We encourage people to use their full legal names. Where families are intact, where the parents are in coordination, both parents will be identified in that first paragraph. We'll talk later about circumstances where that is not the case. And then the second section is where they identify the children by their full legal names and their date of birth. So that part is simple. The hardest part is actually the next slide. And in the third section, Tanya, next slide.
Yeah, I'm still thinking about what you just said with the 2 parents. Yeah, I think
we'll talk about that in more detail about when it might be appropriate for a parent, a custodial parent, to consult with legal counsel.
Absolutely. But the general message is that a single parent can fill it out. That's like we want to make sure that is very clear, and then we'll get into all the nuances of what that means.
Right. Okay, so truly what we have experienced, and we have a lot of experience in the field working with parents on this. The hardest part for parents is choosing a caregiver. They raise a lot of questions about it. It's really, it's emotionally complicated. It's often logistically complicated. But what we advise parents is choose the caregiver and the alternate caregivers who you believe will provide the greatest love and nurture to your children if you're not available to do so yourself. And this is the time when we explain to parents the difference between what we are creating, which is a caregiver relationship, translated into Spanish as a cuidador, and the difference between that and a guardianship or a tutor, which is a court-appointed process. Our document does not require court involvement. It sets up the caregiver relationship, and we do want parents to understand the difference between those two, that by filling out a child care safety plan, they're not entering their children into a guardianship relationship. There's options if they choose that, but that's down the line. That is not what the child care safety plan does. So truly, the only requirement to be a caregiver is that the person be an adult. Next slide. Of course, the question that comes up more commonly than any other is, do they have to be citizens? So we do have a practical response to that question. A caregiver does not need to have legal immigration status. We encourage parents to choose whoever they think will be the best caregiver for their child. However, we have an opportunity, parents have an opportunity to choose a primary guardian and then two alternates if that primary, sorry, not guardian, I take that back, a primary caregiver, and then two alternates if that primary caregiver is not available. And we really encourage families to make sure that at least one of their three choices is what we call stable. Stable means they have legal immigration status. They're not involved in criminal proceedings or activity that might make them not available or not appropriate. They're not terminally ill. And on the positive side, they're not about to go off to Harvard Medical School and therefore would not be available to your children. So, again, parents have to really think long and hard about who they think would be the best caregivers and talk with those caregivers and make sure that they'd be willing to step up to this really important task. And ultimately, once they've decided who to designate as the caregivers in their childcare safety plan, we do encourage them, if they haven't filled in both the primary and the two alternates, that they cross out any unfilled boxes so that nobody comes in later and writes in their name without the parent's consent. Okay, next slide.
Miriam, we do have a question in the question and answer section about the 5 specific points, which were the identifying the parents, identifying children, caregiver, and there were 2 more. Maybe you could say that for everybody. It looks like Rob's typing an answer as well.
Okay, yeah. So the last 2 is that the parent signs that document and that they sign it in front of either 2 adult witnesses or a notary. And I'll talk about that when we get to the end of the document, about the signature page.
And those are essentially the 5 things in order to complete the initial childcare safety plan itself. And then afterwards, you have all the attachments.
Right. And I did want to say that the very first paragraph of the childcare safety plan, where the parents identify themselves by their full legal names, also state the parent's intent that if I become incapacitated, I want this childcare safety plan to kick into effect for the children identified in there. And incapacitated is defined in our document as, unable to pursue your parental activities as a result of physical or mental disability, immigration or law enforcement, military deployment, or anything else that would keep a parent from actively participating in their child's lives. So that's all defined in the document. The parent does not need to write that in. Okay, so I think we've gotten through the hardest question of identifying the caregiver. And we're really encouraging parents to speak with those caregivers and make sure they're willing to step up. The next section of the Child Care Safety Plan, and again, this is all in the template, it references the caregiver authorization affidavit. This is a statewide form that will be amended or has been amended by AB 495. This is where the parent gives their blessing to the caregiver to fill out this caregiver authorization affidavit and use it once the parent is unavailable and the caregiver has custody of the child. And this really cures a big concern about the caregiver authorization affidavit, because many people feel kind of squeamish about accepting it because there is no place on that document for the parent to sign it. But when you sandwich this caregiver authorization affidavit with our child care safety plan, it makes it clear that the parent has consented to the caregiver completing this document and using it as necessary. So next slide. So just so you know, the caregiver authorization affidavit is attached for later use, to be later filled out by the caregiver. Okay, the next section of the child care safety plan is our wish list. This is where we give all of the powers to the caregiver that a parent might want: to sign kids up for Little League, to let them go on school field trips, travel within the United States. It's a list of powers that the caregiver would have. And this is a living document that the parent can modify. So for example, if the parent is not comfortable with one of those powers, like maybe traveling out of state, they can simply cross it out and write their initials and modify it to suit their needs. Next slide.
And on that, Miriam, again, I just want to
Go ahead.
that's such a critical aspect of what we're trying to do is just give as much power as possible to this caregiver so that they don't get that wall and then have to go to court to request guardianship. And we always say also there's no guarantees. You know, we're not everywhere. We can't be everywhere at one time, but this is our best wish to have this happen. And again, in our county, we've done a really good job at working with our stakeholders, our gatekeepers, so they're well aware of this tool.
And it was really important to us in creating that we give parents a template so they don't have to start from scratch to try to write a child care safety plan. This is a template. It has everything in it we think is most critical, and it's also modifiable so that the parent can cater it to their needs and their specific family structure.
We have a
Okay.
question
Yes.
too from Patricia. She wants to know whether or not the caregiver do these forms, this process, give the caregiver the power to make medical and health decisions for the minors.
Excellent timing. Because our next slide is, yes, it is a detailed consent for the caregiver to obtain medical treatment and make important medical decisions. This is also what the caregiver authorization affidavit does. The caregiver authorization affidavit allows any caregiver to enroll a child in school and obtain school-related medical or health care. If that caregiver is also a defined family member or a defined qualified relative, they can get more, they have access to more health care for the child. So in some ways, our consent to medical treatment duplicates what's in the caregiver authorization affidavit as to relatives, but it also goes beyond, and it allows any caregiver to obtain necessary care. And again, this is something, if a parent is not comfortable with that, they could modify this. So that's where, again, this is a detailed consent to medical treatment that is signed by the parents. Next slide. Okay, we didn't put in section G just because it's changes, but it is kind of, section G basically says, I can change this document anytime I want. And if I want to change it, put in a different caregiver, I just had a baby, I want to add another child to this, they can do that. They can, cross out things, modify it. And we simply ask when people make changes that they initial them and date them, because we always want to know what was the parent's most recent wish. Okay, so then we get to the signatures. And this is where we get into this issue of custodial parents and non-custodial parents. We prefer that both parents fill out, both legal parents complete the document together in cooperation and sign it. And if so, go ahead and sign this document and sign it in front of witnesses. If there's a circumstance of a non-custodial parent, this is where a parent will be very well served to consult with a qualified family lawyer. We are really careful not to give legal advice. We often have volunteers who are non-lawyer volunteers helping parents complete this, and we're very careful not to give legal advice about what a parent should do in a family conflict situation. But there are options that can be explored with a family attorney or someone more qualified to do so. For example, if there's a sole custodial parent and the other parent is simply absent or is maybe, presents a danger or a problem, that parent could consider going into family court to seek sole custody. You can also consider if there's some non-involved parent out there, just go ahead. We do encourage a parent to complete a child care safety plan, and they might make the choice to just leave that other parent, let sleeping dogs lie. But they should be aware that if something happens and the parent is no longer able to care for the child, that parent could step up and try to assert their parental rights. And we do have practical experience in the field about how we direct parents in that case, but we don't give them legal advice with respect to their family situations. And again, if there's only one parent signing, we do encourage them to cross out the other signature block so that no one comes in later and signs without that parent's consent. Okay, the next slide is, remember I said sign it in front of a witness or a notary public. The power of attorney law allows for notaries to notarize documents, but also often little known aspect is that also two adult witnesses can, you know, can sign or can witness the signing of a document. It's important that they be adults and that they not be the designated caregivers. They need to be signed by witnesses who don't have an interest in the document. And so if you're helping a family prepare this document, you can be one of the witnesses. And what you're saying by attesting to witnesses is not that you are familiar with it, or you agree to the contents of the document. You're simply attesting that you watched that parent sign that document. Next slide. Okay, so we mentioned earlier, so that's the 5 pages. Boom. You did the 5 pages, you filled out the 5 blanks, signed, witnessed. I mentioned earlier, we do in our packet attach the caregiver authorization affidavit, which we will be inserting the revised caregiver authorization affidavit as soon as it is available. As you're aware, 495 has just modified this document. The reason we put it there is not to be filled out now, is so that the caregiver will have it handy if and when they need it to obtain services for the kid. Next slide. Okay, so remember that first slide that said care, plan, share? Okay, this slide goes to the sharing aspect of that. This is great. A family has their childcare safety plan. They've talked to their caregivers. They're ready in case of an emergency. But if there is an emergency, how does anybody know that this document exists? First of all, we do really, really encourage the families. It's their private document. It doesn't get lodged with the court. They keep it as part of their personal documents. We really encourage families to make copies for their chosen caregivers so the caregivers know where the original document is. We encourage them to let schools know that they have this document, and we'll talk more in this presentation about the involvement of schools. But emergencies don't always happen during school hours. And so what we have is this, we call it the refrigerator sheet. It's a bold document. The parent puts it on the refrigerator and it says, I have made a child care safety plan for the following children. If something happens to me, call this person. And we've also created sort of a layer of safety for immigrant families and immigrant communities. In Santa Cruz and the Tri-County area, law enforcement knows if they appear at a home to look for this refrigerator sheet, to know that a family has created a child care safety plan. But we do also advise that you may not want to put the caregiver's name on that refrigerator sheet. Caregivers may not have legal immigration status. They may not feel comfortable receiving contact from law enforcement. So put somebody on that refrigerator sheet who would be willing to have contact with law enforcement and who knows how to get in touch with your designated caregivers. But it's a bright graphic sheet. And again, you need to train your local law enforcement and CPS to look for that, to know that there is in fact a child care safety plan for this child. Next slide.
I think I saw a question come in about the notaries and the witnesses. I didn't know if we wanted to address that or not, but I think it was an important one. It came from a UCSC individual, I believe Mario, and he's asking about whether or not if foster care, child protective services, social worker were to be involved, if the document would still be accepted if it wasn't notarized.
Well, I can address that. And Kellie put in the probate code section that provides for this. It should be accepted. This is a legal way to verify a document. Many people choose to go to a notary because it has the fancy stamp and it looks more official. However, there's a cost to going to a notary, and it also, we wanted to provide an option for families to do it without the cost and without needing to search out a notary, and without also the risk of somebody, going to a notary and being subject to notary fraud.
And maybe I could add something too, is that the people who are doing the CSPs, some of us are notaries and we're doing it for free if you need to do it, and the power of attorney when you get to that for travel. But none of these are court approved or judge approved documents. They are going to be as much as they can without going through the court system, which is where a lot of our clients are really just terrified to walk into a court. But they do hold some validity. CPS, when they get involved, they're going to look for who the parent most trusts with their children. So they're all good guiding documents, but they're not going to hold up they're not a court document, but they can hold up to at least say this is what the parents wanted when this process, comes into play.
And just
And
to
I'd like to, oh,
tack
go ahead.
on to, sorry,
No, go
Tanya,
for it, Rob.
just to piggyback onto what Kellie was saying. If a child were to be found by Child Protective Services unaccompanied by an adult and taken in and proceedings begun in the court system to determine whether a guardian or whether a child had to go into foster care, the existence of a completed child care safety plan would be a very important piece of evidence that a judge would consider in making that decision of whether whether the parent had made a plan for the child in the event of separation. And so that is, it's not the plan itself doesn't confer the authority that a judge's order would confer when a guardianship is created. But if it should be accepted by all of the various gatekeepers that it may be asked of at school districts and healthcare providers and so forth, even without the imprimatur of a judge signature. But it also does serve in the event of this particular possible scenario where there's a child who's been separated and picked up by the authorities and they're trying to decide what to do. If a judge has to make a determination about whether foster care is necessary or not, the existence of that completed child care safety plan is going to be an important piece of evidence that the judge listens to or considers. And then the only other thing I was going to add is in relation to the question about witnesses versus notary. I agree with everything that Miriam has said on that, but just to add a little bit more context about why we chose to also add the witness option. And part of it is because, as Miriam did mention, or Kellie mentioned, while some of the people who are volunteering at family orientation events might be notaries, myself included, most of us aren't. Most of the people there helping families complete these forms are not. And it's nice to be able to have the families be able to leave those sessions with a fully completed form that has been validly witnessed. And the other thing kind of in that topic that was briefly referred to by Miriam is that unfortunately there is such a thing as notary fraud, and you may all be aware of it, but for the ones who aren't, in Spanish, especially in Latin America and Mexico, the word notario público, which literally is a translation of notary public, also in those countries, a notario público is more than a notary public is here. And here, a notary public is just a person who's taken the notary public exam that's put out by the California Secretary of State and passed the test and paid the fee and the bond and is able to put a signature, put a seal on a document that says the person who signed this document proved to me that with their ID that they're the person who actually signed it. That's all a notary does here in California. But in other countries, notario público is actually a term that's used to describe an attorney, a licensed attorney. Knowing that, people of bad faith have leaped into the lurch in a lot of immigrant communities and hold themselves out as notario público and imply that or insinuate that they're also able to give legal advice. And so it's nice to be able to have a witness possibility to complete this document that doesn't require that people might, although it's pretty rare, but it happens. And so it's nice to give them an opportunity to not have to even have any risk of falling victim to that kind of stuff. So that's all I had to add on that.
Thank you so much, Rob. And so back to the question with the question. So I absolutely true. We wanted to avoid the concerns about having to go to a notary, and we are aware that certain individuals, for example, airlines, for example, some child protective services, sometimes they like that fancy seal. So we really, and I think it did come to us. It was a social worker who brought that to our attention at one point, and so we actually made sure we did have both options, and that's why there are both options. But it is the law that it should be accepted with just the two witnesses. All right, back to you, Miriam.
All right, I think we're on the next slide. Hopefully that answered the question. Okay, I've got the fridge sheet. Keep going. Okay, the next thing is we have another optional attachment, highly recommended. Several pages where the parents give all of the necessary information about the care and feeding of their children. Everything from where do they go to school, who is their doctor, what medical conditions do they have, when do they need their meds, what do they have a pet, what's their favorite ice cream, what are their extracurricular activities. This is all of, it seems burdensome, but this is all of the information that a caregiver would want to have to provide a smooth transition of care for a child who has just been traumatized by the separation from their parent to someone else's hands. So, we encourage parents to complete this additional information in as much detail as they're able to do, because it will make an ultimate transition to a caregiver much smoother and safer for the child. Next slide. Okay, another optional attachment, we referenced this earlier. This is a power of attorney for children to travel abroad. And what this is, some families do, their goal ultimately, if they're separated from their children, would be for their children to stay in the United States, to graduate from high school, and not to come back to the country of origin to reunify with the parents. Other families, typically with younger children, their goal would be that as soon, if the parents are facing deportation, that as soon as the parents are safely settled back in their country of origin, one hopes, and not some third country, that the children would be transported to join them. And in order to do that, somebody needs to be able to take that child on an airplane. So we have an optional power of attorney for children traveling abroad, which identifies the agent who would have the authority to board an airplane with that child, or a bus, whatever it takes to get them back to their country of origin. And there's more detailed information needed to complete it. Children will need passports, presumably, at some point, and that's something else part of family preparedness, is getting your kids whatever passports you can get. So this is another optional document. We do, again, they can have two witnesses or they can be notarized. It is designed to be acceptable by airlines and other transportation couriers. So, again, it's an optional document, and most important for families who would like to reunify in the country of origin after the immigration emergency.
Just to hop in there real quick, Miriam, this is,
Sorry.
the practicing estate planning attorneys out there may recognize this power of attorney for children traveling abroad. It's something that has traditionally been a sort of a legal instrument that has been provided to parents in our normal estate planning practice for when they go on vacations or trips, and maybe only one parent's going to go, or a grandparent's going to take the child. But it's just, we've included it here. It's a document that even though it is something that is fairly regularly provided, and sometimes it's required by airlines, and sometimes it'll be required also by immigrant or sort of customs and immigration abroad. We've included it here, and it's hopefully not something that anyone would have to use, but if they did, I think that it gives parents some peace of mind that they've authorized someone to bring their kids back to them.
Rob, I'm going to ask, there's a good question too in the And the question about whether or not the POA allows for the child to travel alone as an unaccompanied minor for service on an airplane, or
Yes.
do we think this form is going to require that caregiver to be traveling with the child?
So we have both options. They can click whichever option is more appropriate for their family. So we do there's several options in this document. One is it effective immediately, or does it spring into action upon my being deported? So the parents can choose, and then there's an option to allow the child to travel alone if the parent feels the child is old enough to do so.
And I see there's also another question here in the chat that the question is, who advises the parents about this choice between utilizing witnesses versus seeking a notary?
So again, we're not advising, we're informing. So that's the key. The key here is that we're going to provide people the options and help them try to understand the pros and cons, and that we are not making the choice for them. And that's the same with this power of attorney document. And I don't know if Miriam or one of you want to address that a little bit as well, but we're really, really careful about the risks. We're really explaining the risks and having parents, choose knowingly whether or not they feel like they want to use this tool and who they're going to name. It doesn't have to be the same caretaker, so it's really, I always say, how much faith do you have in this person? Is it, is it your abuela or is it your neighbor? Is it, how you got to really talk about those things. You want to say
That's a
more
good
on
point.
that?
The person who
And
travels with the child needs to have immigration status that allows them to leave and return if that is their goal.
that's
So,
right. And then, I think we also have we explained to the parents that, if it sort of depends if you are choosing between whether to have a notary's acknowledgement or witnesses, sort of depends also a little bit on where you anticipate that the documents um, are going to be presented, what gatekeepers will be looking at it. If for just the child care safety plan, it's likely to be local authorities at school districts and healthcare providers and so forth, and witnesses should be perfectly fine. If a parent has made the decision that they do want to have this optional power of attorney for children to travel abroad, it probably makes sense to have a notary seal on there, just because you're talking about gatekeepers that are going to be customs and border enforcement in maybe other countries, and a fancy seal looks a little more official. So those are kind of the things that we advise, that we explain to parents about, to think about when they're making the choice.
And that folds right into another question in the chat, and it might be farther out than just the child care safety plans, but asking what, if the child themselves is if they're undocumented, is there going to be a risk that that child can be detained in the airport? Do they need their own travel documents? And it's a really good question.
it's an excellent question, and that's really getting into the area of immigration law. And I'm going to say beyond the scope of this conversation, but I would love to have that conversation down the line. Another thing
And
about travel abroad is that these decisions don't need to be made right now. The reason we include the power of attorney for travel is because it's convenient to do so now while the parents are here. We might have a notary there at the event. These things could be dealt with later after the parents, I hate to say it, have been deported. But if parents have been deported to a remote village in Guatemala, it may be very difficult to complete documents from afar. So we do like to do as much as we can within the parents' capacity while we're meeting with them and putting together this packet.
but we also, and as Miriam was explaining, the main sort of nuts and bolts of this long packet of the CSP plan itself, the main nuts and bolts, or the main tool, is the first 5 pages, which is the safety plan itself. And then all of these additional documents are possible additional tools that can be used if they want. And they don't need to complete the entire thing all in one sitting. And this packet is going to include these additional bells and whistles that if they choose to later decide, hey, I've been thinking about it, things are a little different than when I was over there, I think I understand a little bit more about this decision, they will have these additional tools that they can complete and add to what their plan for their child is.
And I want
Hence,
to get to the
Swiss,
very, oh, go ahead, Tanya.
I was going to say, hence the Swiss Army knife that we first spoke of. With those first 5 pages is designating the caregiver, and then you can choose the additional tools that you're using after that.
So the last part of the packet, also a very important one, is the an optional nomination of a future guardian, and now we've modified it to be a joint guardian, anticipating AB 495 coming into effect. And this is again, up until now, we have hoped and assumed and planned for the Childcare Safety Plan to really allow a caregiver to meet all of the children's needs, medical, school, social, all of those things. There are sometimes circumstances where a child care safety plan will not be enough. And a couple of the things we've thought of, if the child needs brain surgery, a medical facility may not be willing to do brain surgery on a child without the parents or a legal guardian's written consent. Or we've also anticipated sometimes for children to get special education services from school districts. They may require a parent or a legal guardian to participate. So there are these outer limit cases where a guardianship, going to court for a guardianship may be in the best interest of the child. And we would, certainly would not discourage anybody from doing that. What's most important here is the best interest of the child, as well as preserving parental rights. So we have an optional document where a parent can say, I want this child care safety plan to take care of the things, but in these unusual circumstances where my child does need court intervention, here's who I would like to serve as the guardian. And now we will be modifying to here's who I'd like to serve as a joint guardian with me. So again, that's an optional document. And this is a matter of sensitivity. I mean, it's already so difficult for parents to be considering being separated from their children and doing this work. And they only have so much capacity. But I think it's really important for parents to know that they can continue to assert their desires down the line as circumstances change, and to bring them before a court if a court proceeding is ever necessary. I think that is the last slide on the actual document itself. Is that correct?
I think so as well. Although I just wanted to not totally leave unanswered that prior question about the unaccompanied minor who didn't have papers or wasn't documented. While Miriam is absolutely correct, we ourselves are not immigration attorneys. We do consult with many immigration attorneys, and I just want to make sure that it's clear that yes, that is a risk. I mean, you're not. No. Very, very concerning if you were to send a child that did not have papers right now into an airport. So we're not recommending that in any way, shape, or form.
Right. And even if they could succeed at leaving the United States, they would have very great difficulty returning if that's their goal. So if a family is in that circumstance, they would definitely want to consult with an immigration attorney before showing up at the airport.
That really is a great question. And I think it's maybe a good time to make a little bit more detailed comment about the practice of law. And so what we and what in our trainings for volunteers who are assisting families, there are certain aspects, and one of them is that we're not giving legal advice, and we're just informing families of the options, helping them to prepare, make a plan. But when it comes to certain things like should I'm separated from or estranged from my child's other parent. Do they need to sign this? And what does it mean? Those are areas where we recommend to whoever we're talking to that they seek legal advice from people who are qualified to give it. Such as in that case, it would be you need to talk to a family law attorney. And get some baseline information about what your situation is and what your rights are, and so forth. The same goes for questions that relate to immigration status, potential, how it might affect somebody's eligibility. Something might affect somebody's eligibility. What they should what types of things they should include in an immigration application and what type of status they might. Those are all questions that that we always recommend to the people we're talking to, that they seek legal advice from people who know. And in fact, the packet itself has towards the back a lot of, at least it, and this is something that each county would probably need to have its own contact information, but we have a lot of referral information to different nonprofits that provide legal advice and other lawyer referral services and so forth, so that people that we're talking to, when we say you should talk to somebody who knows about that legal area, that the packet itself has some information that families can use to contact somebody who does, which isn't going to be us, but and then maybe once they've talked or consulted with those attorneys, they'll have a better idea about how they might want to go about filling out certain parts of the form.
We have a couple of questions, if I can jump right in here. One of them is back towards the joint guardianships, and people are having, of course, relatable issues about guardianships taking away custody from a parent. So wanting to know what the joint custody is, perhaps we could speak a little bit more about that. And also about resources, but I really think you just answered that, is each different county is going to be able to gather together its list of either social resources or no cost legal aid information. And for anybody just in any part of the state, if you've got questions about that, there is on the state's CalBAR website, there is a list of local nonprofit organizations, and not like the Senior Legal Aid, Legal Services for Seniors, CRLA, all of those folks, either they can help you because they're going to be going through this process for legal questions, or to almost a person, they're going to be able to say, we don't do that, but we can get you in contact with somebody else who can.
I just want to mention with Cindy's question and what Rob was talking about as well, with response to Cindy's question, with non-lawyers, providing these tools. This really has been, in our hope, a grassroots effort, and we've really done the best that we could to give these to families to take it themselves. We've done train the trainers. It's really about individuals supporting one another in mutual aid. So we really, don't believe that you need a lawyer in order to fill out the bulk of this document, at least those first 5 pages again. So I just want to reiterate that. And I think these next slides are actually yours, Rob. We're going to have you talk a little bit about how CSP kind of fits it, how it's like other formal and informal legal documents, and then go into AB 495, which will address the question that came up about the new joint guardianship and how that changes that field.
Absolutely. And this is a lot of what this next slide here I'll be talking about, is probably some stuff that's pretty familiar to a lot of the attorneys, or at least the estate planning attorneys. But for the rest of you, in estate planning, it's a kind of a fancy word. I think a lot of people think that it implies sort of financial planning and so forth. In my line of work anyway, at least in my practice, that's not it. It's basically just sort of current testamentary planning that is designed to allow people to put into legal tools or binding legal documents what their wishes are now, while they're still competent and before they die. And part of the toolkit that we always include in, for example, a revocable trust estate plan. Besides the trust itself, which is mainly designed to avoid probate and so forth, there will be, and also to tell, to leave instructions about who's going to inherit stuff. We always include also documents that will allow people to name others to do things for them if they're unable to. And by unable to, it's for whatever reason. If you if you suffer a stroke and you're incapacitated mentally and you're not able to take care of your own affairs, you can't pay your own bills, you can't sign contracts for caregivers and those types of things. If you have a durable power of attorney in place, then name somebody who can do that for you in that event. Also, if you have if you're out of the country or out of the state and you forgot to transfer money from your savings to your checking before you left, and you sent a mortgage payment check off, and you need somebody to get down to your bank, your local bank, and transfer money. If you have a durable power of attorney, that person can take that document and the bank will deal with them and do what they ask. And the same goes for healthcare decisions. If these types of, if you're incapacitated and you have an advanced healthcare directive, that document will allow the person you've named in the advanced care directive to discuss confidential medical information with your care providers and to make decisions on your behalf, in line with your wishes about things like life support and so forth. If you're or if you're terminally ill, what kind of treatment you'd like. Those are examples of the types of planning that we already have, advanced planning for things when we're unable to. The Childcare Safety Plan fits kind of right into that family of legal tool. Another document that we'll will frequently include if people who are our clients have minor children is a nomination of who's going to take care of their child. So this Childcare Safety Plan fits right in with that family of documents. But the Childcare Safety Plan is designed to be used by a proposed caregiver without having to go to court. With our normal, sort of traditional planning, what a parent with a minor child will do is to nominate a guardian, and that is something that eventually, if it's needed, is going to require court involvement, and in the form of the proposed guardian filing a petition in probate court and getting a judge to approve the guardianship, or to find that the guardianship's needed, and to find that the person who's been proposed is an appropriate placement, and then to sign an order that puts in place that person as the official guardian for the minor. And once that happens, that person can do practically everything for the child that a parent could do. But some of the drawbacks to a guardianship petition, as a lot of the family law and probably estate planning attorneys here might know, is that it's not easy. It is a process that requires the completion of a ton of different judicial counsel forms. You have to, of course, as with every court thing, you have to meet all the procedural requirements for notice and so forth. And so it's a very onerous thing, even for people with attorneys. And if you have an attorney, it's probably costing you a bunch of money.
But we don't even know now, because AB 495 is going to change it all up.
And we hope so. We certainly hope so.
Right.
AB 495 is some great new effort by our legislature to address the issue of family separation, and to hopefully make the entire landscape less traumatic and disruptive for families when there is separation of parents from children. And what AB 495 does, it's sort of a multi-pronged approach to alleviating that disruptive situation. What it does is amend a series of parts of the California Code. It amends portions of the Education Code, also of the Family Code, and the Health and Safety Code, and also the Probate Code. In the Health and Safety, the Family Law Code amendments, It amends the part of that code that provides for the caregiver authorization affidavit. And when it comes to the probate code, it amends the probate code to provide a new type of potential guardianship that is a joint guardianship, and I'll talk a little bit more about that in a second here. It also amends the health and education, or the education code, to provide that a number of privacy improvements for children in schools with respect to immigration information. And it works in the health and safety code in regard to childcare safety plans. And so to go into, and I'm not seeing the, maybe next slide, I think. Okay. Maybe next slide too. Okay. The part of the family code that currently contains the caregiver authorization affidavit provides that somebody who it creates a document where whoever has currently is living with a minor child who may not have their custodial parent there at the same time, that person can sign this document. So it's not a document that is signed by the child's parent. It's signed by whoever is taking care of the child. And it has two different things that it does. If you are any adult over the age of 18 who's caring for the child, and you sign it, you're going to be checking, I think it's boxes 1 through 4, or items 1 through 4. And that is going to basically say to school districts that you have the authority under the statute to enroll a child in school and to provide authorized medical treatment in a school related setting. The second category of people are going to be people who are related to the child in a family affinity or kindred way, and they're going to be checking or having application of 8 different items. That class of people under the current caregiver authorization affidavit, they have authorization not only to enroll a child in school and authorize school-related medical treatment, but also generally medical treatment from any care provider. The AB 495 expands the group of people who qualify as family for that second class, that second category of people with broader ability to authorize medical treatment. And the way that it expanded is the same list of people that's in the existing definition of qualified relative, but it just expands it by saying that now it will be that group of people within the 5th degree of kinship, and degree is a technical word in the probate code that refers to generations. So it sort of makes that definition of family bigger by making it apply to 5 potential generations. The caregiver authorization affidavit is something that should be honored by gatekeepers in the schools and the medical providers, but it's also important to note that the law does not require that they do that. But the document itself says that if a gatekeeper in either of those arenas does accept authorization provided by a caregiver under that document, that they will not be liable legally.
And I think you're going to talk a little bit about AB 495 not only requiring schools to look at the CAAs, but other aspects as well. I think that's on a later slide.
That's exactly right. The education, it is on a later slide, and so keep going on down. That's okay. All right. So instead of going to that aspect, Tanya, I'm going to talk a little bit about this joint guardianship reform. This is the part of AB 495 that makes amendments to the probate code. Currently, a person, a court can appoint a guardian for a minor child upon proper petition and the court finding that that person's an appropriate placement. The nomination of that person by a parent in a written document is going to be very important information a judge considers. Currently, there's only one type of joint guardianship. So the normal run-of-the-mill guardianship petition is for one person or two persons together to be a guardian for the child or co-guardians. But there's a separate category currently for a joint guardian who will be appointed upon petition by a parent who is terminally ill as defined in the statute. And the new AB 495 amendment provides the same thing essentially, but it's designed to allow a parent to be appointed as a co-guardian with another non-parent. And the intent is to make it so that that joint guardian will, in the event of the absence of the actual custodial parent, would have already in place all of the things that they need to do to take care of the child as a guardian. It's kind of early days. This legislation was signed by the governor only on October 12, so it's only been in place for a little over, so I guess about a month and a half or so. And the legislation doesn't come into effect until January 1 of 2026. As with everything in the law, the details will be important. And we don't know all the details for exactly how that process will work in terms of what the procedure will be, and also what the judicial council forms will be that are produced for this new type of joint guardianship. We're hopeful that the result will be something that is much easier. Part of the intent is that, and also the language of the law is that once established, a joint guardianship can be easily undone once the parent returns and is able to parent again. And in the new legislation, there is a presumption that upon request by the parent that the joint guardianship should be terminated. So we're hopeful that it's going to really make a great change. We don't know enough yet, unfortunately, and it may be a little while before the Judicial Council gets around to coming up with the forms, and those forms are going to have a lot to do with how things end up being from a practical standpoint. But we're very hopeful and grateful that the legislature has moved into this area. The main intent of AB 495 was to address family separations, especially in light of the increased immigration enforcement that we're seeing nowadays, and to ultimately create an environment that could be less disruptive of families in that arena. And then
Just to
lastly,
give a time check,
sorry.
just to let you know, time check, we have 15 more minutes. Just want to let everybody know where we're at. And I was just going to say, so Rob pointed out to me with respect to the joint guardianship, he kind of set me straight recently, that this new joint guardianship is adding on to a current joint guardianship, which does already exist in the probate code, which is for terminally ill parents. And in that situation, when a terminally ill parent is a joint guardian, the parent has to be present at some point, either for the court investigation or for at least the signing of the letters And so we're still waiting to see how and if the court is gonna handle this so that this new joint guardianship is actually effective and useful for families. So that's the big question that we're waiting on right now.
That's right. That's a good point, Tanya. And I don't think I explained it well, but what I think we're really hopeful for is that whatever procedures ultimately are created to address this amendment to the probate code, that um, it would allow for the possibility of a parent to nominate somebody to be a co or a joint guardian with the parent and not have to immediately file a petition in court and see it through to an order by a judge before the joint guardianship can be created. Because if that's the case, it's not really very practical. A lot of the people that we're trying to help with the Child Care Safety Plan are not going to be inclined to have to go to court and do that whole process for not only fear of immigration purposes, but also because it's just really hard and onerous. And so it'd be great if this new legislation is going to allow them to nominate beforehand a joint guardian, and then that proposed joint guardian, if the parent is separated from the child eventually, that at that point, that person could petition the court to be appointed as a joint guardian with the parent, even in the parent's absence. And then a judge could give that person full authority with a formal guardianship. And then when the parent comes back, it'd be really easy and cheap to get it undone. That's what we're hoping for, but we just don't know yet.
All right, I think you just went through most of that. This is just, again, talking about how the Child Care Safety Plan fits in really, really nicely with these new enhanced tools that we've already, previously provided all these documents, and now we can do it on an even stronger basis.
That's right. And that portion there has to do with the amendments to the education code. It requires schools and daycare providers to look to a parent's safety planning for things like emergency contacts and who can pick a child up from school, and also prohibits them from collecting or sharing immigration related information. So those are important pieces of this puzzle that this new legislation addresses.
And this is the important part that we were starting to talk about yesterday, or not yesterday, just a few minutes ago, with the designated caregiver instruction that is required again by AB 495.
That's right. That's right. These the AB 495 amendment to the education code requires schools to honor whatever safety planning a parent has in place. And that would include the Child Care Safety Plan that we provide. And that's one of the aspects of this new law that's important.
All right. Oops. And you think you already said when it was going into effect, I believe?
I did.
Okay, great. Well, then that takes us, I think, unless you have anything else you want to add, Rob?
I don't. I think that pretty much covers it. The legislative analysis is always the most boring part of any.
Well, we gave you the hard part, that's for sure. And we appreciate you taking that on. So I'm going to talk about the fun part. Oh, wait, first we added these in, almost to the fun part. I just wanted to quickly share a little bit about how the Child Care Safety Plan fits in the Judicial Council and in the statewide. We're starting to talk about the statewide arena because we've been in Santa Cruz County since 2017. Monterey County joined in almost immediately. San Benito County has also joined us. San Luis Obispo is using our tools. Alameda County has adopted our tools, and Contra Costa has been trained, and Sonoma County is interested. So we are slowly just happy to share these toolkits with anybody who wants. And just in the Judicial Council right now, if you see when this is what you turn to, and they will have you fill out a family preparedness plan. And the concern is that when you get to these plans, which are super important, because as I started with, this is family preparedness in the large part, but most of these plans tell you to make a child care plan. But where's the plan? So I just want to point out again that, this is the plan. It's right there. And so that's what we're talking about. And excited that the AB 495 in this moment also mandates that the Attorney General do some work. So I'm sure they're all thrilled about that. They're busy modifying and updating their policies to make sure that schools and childcare facilities are aware of the changes and new requirements. And they're also required right now to inform parents about some of the family emergency preparedness. So our team has been working really hard to try to get the Attorney General to take the Childcare Safety Plan right now and make it be a statewide model. We really, really, really want there to be a free, easy to fill out, non-complicated, did I say easy? It's something that's simple that people know that they can turn to. We're concerned about some of the differences that are out there. We really want there to be a uniform template, whether it's ours, it's not necessarily, it doesn't have to be, but we just really want the Attorney General to do this. So we want you to know that we do have this initiative out there right now. We have this petition. We're slowly collecting signatures, and we'd be really happy for you to share this. We are actually meeting tomorrow with the Attorney General's office. So we'll have a conversation with them about some of their work with family preparedness in 2026 coming up. So we really appreciate your support with that effort. And again, I mentioned that we are happy to have other counties take this, other organizations take this. The packet that you download from our website or from the Sus Derechos website, or it's also on lawhelpcalifornia.org, LAC's website. When you download it, the first 6 pages or so is all information, and some of that is county specific. So you are welcome to replace those first pages with your own pages, your own resources, and then include, the 5-page CSP and the attachments thereafter. We recently provided the whole thing in a Word format to Sloloff in San Luis Obispo. So we're happy to do that. You guys can, take it and use it as you wish. And I think that's it. We have about 7 minutes left, and I'm happy to address any other questions that we may have missed. The link for Alameda County, who's our contact? Anyone remember our contact in Alameda County? I don't have their link. I don't. They just email us.
I was just going to say, I'm just getting ready to put our global email into the chat. So if you've got more questions or comments or didn't get to them, or like me, think of something 15 minutes from now, send it to that email. And any of you've heard the panel who are fantastic. We'll all be happy to answer those questions. There have been a couple of questions too about people meeting with their individual groups. And we would also, depending on where they're at and what time, I believe anybody in this panel and pretty much anybody from CSP would be happy to meet with you with your particular individual groups to give presentations and dig into this more as well.
Absolutely. We've done 30 this past year around the county in various places. I recently did a presentation to the Contra Costa Immigration Coalition. So we're more than happy to reach out to the various groups. But again, we want you to take it and run. Well, we're super happy for your time today. I know it's a big chunk of time and we are all pressed for it sometimes. So again, thank you for your hearts and your care and the comfort that you are providing for others. There are a lot of ways. Cindy is asking a question about helping to organize efforts locally. We're right now working on organizing communities from within. We do have a lot of ideas. We've been at this for a long time. Organizing communities from within, is a lot about teaching teachers and teaching students and teaching parents and empowering them to know that they can take this and create their own events, supporting them in creating their own events. The ELAC, Migrant Ed, these are amazing partners to work with. I think Rob and I early on went into, a few ELAC meetings, and when you're invited in by a trusted messenger and then can work with a small group, that's often works well. But also, again, when we can get together and inspire people to learn it themselves and then train them and then help them create the events. I think one of the documents I'm going to ask Kasia to share is one of our Dia de Familias Preparadas, which we are now working on. So we have that flyer. I'll share that flyer with you. But that was a school district in Santa Cruz County is taking that on. And so they have their community support specialists within the schools who are trained. And again, having the people within train and then have the events. I'll say that one more time, is probably one of the best ways to work and organize locally.
And the only thing I'd add to that, it was great, Tanya, but I would add on the one hand, getting is the work with the families. On the other hand, is work with the gatekeepers. And so we've also spent considerable effort educating and working with gatekeepers, like people at the County Office of Education, the people at Salud para la Gente, which is a great local nonprofit healthcare provider. They see this tool as something that really helps their healthcare providers. So they've really worked hard to encourage all of their patients to have one of these in place, to have somebody, and they have committed to honoring a completed plan. Same with the local school districts, and our great county council, and also the Child Protective Services. So all of those gatekeepers are an important piece of the puzzle too.
Yeah, and I think that really goes to our statewide effort. To the extent that we can encourage the Attorney General to adopt this as a statewide template, it not only does it give families a great resource that can be, presented to them through trusted messengers like schools or healthcare providers, but the gatekeepers will be much more inclined to honor the parents' wishes. So, we want to get parents away from this kind of like ragtag. There's this template here and there's this template there, but don't do this, do that. And just say, this is a unified effort to protect our families.
Okay. Well said.
Yeah. Sign the petition. We're meeting tomorrow. It's our last day to get as many as we can and share it with your networks. Thank you so much.
Thank you, everybody.
All right. Thank everybody for sticking with us and for the work.
I wonder if we can get the petition link in there. Is that possible? Oh, it's there. It's already there. Never mind. Of course. Thank you.
You
Take
to
care,
our
you guys.